Hello my dear friends and welcome to StudyIQ. I am Joycey Joy and today in this lecture we will discuss about the Supreme Court order that granted bail to the journalist Prashant Kanojia. Now if we look at the current affairs, the Supreme Court has ordered granting an immediate bail to journalist Prashant Kanojia, who was arrested by the Uttar Pradesh police. The UP police had arrested him and now the Supreme Court has ordered for granting an immediate bail to him. So based on this current affair, we will have a brief discussion about the judicial system in India altogether, and we will also see what were the abnormalities in the arrest of the journalist, and we will also understand what is the court's observation in this regard, or what observations has the Supreme Court made, and what is the way ahead, and how can be the Indian judiciary strengthened more. So we will discuss all this from the perspective of UPSC preparations. So this is a very important topic for your GS paper 2. So the topic judiciary comes under your GS paper 2 for your mains examination. So this lecture will cover the topics that we have discussed and which comes under the subtopic Indian judiciary under paper 2 of your GS paper for your UPSC mains exam. So before we move on to the current affair, what was the arrest for, what were the abnormalities in the arrest, the court's observations, we will first have a discussion about Indian judicial system. So this will be very much helpful for giving you an understanding or a conceptual clarity about the Indian judicial system, which will help you in attempting even the prelims questions, which requires a high level of conceptual clarity. And even when you write your mains answer, if your perspective is clear, if you can put your ideas very clearly before the examiner, this will fetch you extra marks. And as I always say, when you write an answer about the judiciary, first look at the demand of the question. If the demand of the question is to analyze the integrity of judiciary or independence of judiciary or any shortcomings in the judiciary, you must be able to quote examples as well. For example, if one question is asked about the integrity of judiciary, so you can very well quote some of the judgments or verdict of Supreme Court or any other court in that regard, which has upheld the integrity of Indian judiciary. So this is one common point that I make sure that my students, while writing the answer, they try to bring in such type of examples. So now we will briefly discuss about Indian judicial system. So India, as we all know, it's the world's largest democracy, and Indian judiciary is an integrated as well as an independent judiciary. So we have the Supreme Court at the top, it is the apex court, and we have high courts and below that lower courts. So this is the this is the hierarchical setup of judiciary in India. So within this hierarchical setup, the judiciary tries to maintain utmost independence and integrity. So in order to maintain the integrity and independence, it is highly impartial. It is not partial or it is not biased towards any political party, any political ideologies or any other communal ideologies. It is impartial and also it is independent from the executive. So the legitimate expectation of citizens of a country from the judiciary is fair judgment, that the judiciary should not make any bias when it gives a judgment or a verdict. So fair judgment is what is the legitimate expectation of citizens or common citizens of a country. And the Indian judiciary has proven many a times in the past that it is fair and free with regards to its judgments. From many of the watershed verdicts, Supreme Court or any High Court judgments, it is very clear that judiciary is very fair in delivering justice to common citizens. And in order to protect the integrity and independence of the judiciary, there are also constitutional safeguards. The Constitution itself safeguards the independence and integrity of the judiciary. And the courts, the judicial system also has the power to deal with the case of vulnerable sections of a society. And these days we have seen that there is judicial intervention in public matters in the form of PIL, public interest litigation, etc. And the judiciary also has the power to enforce the fundamental rights to issue writ jurisdictions. High courts and Supreme Courts, they can also issue writ jurisdictions, and enforcement of fundamental rights are also a power of the judiciary. So when we talk about the integrity, independence and constitutional safeguards of the Indian judiciary, there are also certain hurdles to full-fledged justice delivery in the Indian judiciary. The first hurdle would be the time that is consumed in the judicial process, and it has led to pendency of cases. This is because the time involved in settling one dispute or verdict for a particular case takes a lot of time. So this time consumption has led to pendency of cases, and the number of pendency of the cases in the Indian judiciary is coming up every year. Now, second hurdle is the high cost of judicial procedure. Suppose if you want to hire a very good advocate, a very experienced advocate, the process itself is very costly. Apart from the judicial charges, the court fees, the fee for the advocate, in order to get justice for you, the cost is very high. So the high cost of judicial procedure is another hurdle. Now the third hurdle is the unfilled vacancies. So there are a lot of unfilled vacancies in the Indian judicial system, especially in the lower courts, and it varies from state to state. So this is also one reason why there are huge number of pendencies. So these are all some of the hurdles. So my idea was to give you a brief understanding about the Indian judicial system. Now, having understood the Indian judicial system, let us come to our current affair, that is the Supreme Court order to grant immediate bail to the journalist Prashant Kanojia. So we will see what are the abnormalities involved and what significance does the present Supreme Court order make, and we will also see what has to be done. But before we move on, this is our channel StudyIQ, and we are providing pen drive courses for various competitive examinations including SSC and bank courses, UPSC optionals, SSC JE courses, teaching examination, railway examination, defense examination, RBI grade B, NABARD grade A, UGC NET, UPSC Civil Service Examination, for CLAT exams, for various state PSCs, and also for various professional courses. You can visit our website www.studyiq.com for more details, or you can call to any of these numbers for more information. So we have already discussed what is the current affair. The Supreme Court, the apex court of the country, has ordered granting immediate bail to the journalist Prashant Kanojia, who was arrested by the Uttar Pradesh police. So we will see what were the abnormalities in the arrest. So the incompatibility in the arrest we will discuss first. So the arrest of the journalist was for sharing a video pertaining to the CM of Uttar Pradesh. So the journalist had shared a video which was pertaining to the Chief Minister Yogi Adityanath, the Chief Minister of Uttar Pradesh. The journalist had shared this video on Twitter, and that was the reason behind the arrest. Now secondly, if we observe the reasons for the arrest, we will see that it was arbitrary and unwarranted. So we are living in an era where the media has activated, or the media is hyperactive. So the role of social media in such a society is very high, and it is practically impossible that the police can arrest each and every distasteful material that is published in the social media. And in this circumstance, the police choosing one or two persons that post anything or publish anything in the social media who target the political functionaries, it is arbitrary and unwarranted in nature. So if we look at the reasons of the arrest, it is understood that the sharing of certain matter or a video on Twitter was aimed at a political leader, the Chief Minister of Uttar Pradesh, Yogi Adityanath. Now the arrest is also posing a question on the law and liberty, individual liberty. And in this case, the person was arrested for defamation. So basically two offences were charged against the accused. First one is defamation, and the second one is section 66 of the IT Act, Information Technology Act. Now, if we look at the procedures that were followed, we will see that the procedures were also not followed properly. So there was no ground for remand in this case, and Kanojia, the journalist, was taken out of Delhi without a transit remand from a local magistrate. So a transit remand is compulsory or mandatory when an accused is taken from one state to another. So that procedure was also not followed in this case. So because of this, because the procedures were not followed properly, the UP police, the Uttar Pradesh police had to face a lot of criticisms. So in order to give a legal backup to the case, the UP police added an additional section, and this section dealt with the offense of causing mischief and disturbing the public. So in order to create a legal backup, an additional section was added along with defamation and section 66. And later, in addition to it, section 67 of the IT Act was also added. So section 67 of the IT Act relates to sharing of obscene information or material. So this was added with the motive of obtaining a remand order. So if we look at the procedures followed, we will clearly understand that the first happening was the arrest of the person. So first thing that happened was the arrest, and which was followed by the creation of justifications for the arrest. But normally in ideal cases, what happens is that first the police will have to come with justifications for the arrest, and if there are enough grounds, the person or the accused would be arrested. But in this case, what has happened, first the arrest had taken place, and secondly only the police came up with justifications for the remand and arrest. Now let us come to the court's observations. So the Supreme Court, while granting the immediate bail, observed that there are no sufficient grounds for remand of the person. So the Supreme Court bench, which considered the case, said that there are no sufficient grounds for abridging the personal liberty of a person. So the controversial tweets that were highlighted by the police were not enough grounds to remand a person or to arrest a person, and this was a clear violation of personal liberty according to Article 21. So this was the observation made by the Supreme Court. And the Supreme Court also ignored the technological or technical objections that the council came up with. So the state government had a council. So the council of the state government came up with certain technical objections in granting the bail. So the Supreme Court also ignored the technical objections. So the technical objections raised by the State Government Council was that the Supreme Court should not technically involve in this case, because this is just regarding the granting of a normal bail or a regular bail to a accused. So this was the technical objections made by the state government, but Supreme Court completely ignored it and granted an immediate bail to the journalist. Now, what is the way ahead? First one is regarding the judges or magistrates or the judiciary. So the magistrates should not pass mechanical orders without application of mind, because Indian judicial system has its own integrity and the democratic values are also upheld by the Indian judiciary. So it should not do anything that harms the democratic values or the judicial values, the law and order system in the country. Secondly, regarding the officers, whether it is police officers, bureaucracy or administrative staff, the officers who carry out legal instructions should be appreciated. At the same time, those who carry out illegal instructions from the political leadership out of political pressure should face disciplinary action. So the bureaucracy, administrative staff or the police, the law and order maintaining institutions should not be carrying out illegal instructions from the political leadership. You can find the PDF of this lecture on our website www.studyiq.com. You can follow my Facebook page for more video updates. You can also write to me at joyce.studyiq@gmail.com for any of your queries and clarifications. Thank you.